Hello and good afternoon, everyone. Thank you for joining me. My name is Nancy Lugo, and I'm an attorney with Bay Area Legal Services Senior Advocacy Unit's Independence Preservation Project. This presentation is made possible with funding from the Community Foundation of Tampa Bay. I'm going to ask all of you to do me a big favor, and if you could please enter your zip codes in the chat box, that would greatly help us in tracking the areas in Hillsborough County and beyond that we're reaching with this presentation. And we can use this for our grant reporting purposes as well. So if you can just take a moment and enter your zip codes, I would very much appreciate it. Thank you. During these last 2 years of uncertain and challenging times under COVID-19, Bay Area continued to serve our community, providing legal assistance to eligible clients with civil legal problems. I have our grant coordinator from our Senior Advocacy Unit, Tina Marie Jones, assisting me with the slide presentation. Next slide, please. We assist with a variety of legal problems, including bankruptcy, child custody, including relative caregivers of minor children, caregiver advocacy, where we help adult caregivers of seniors or of those with Alzheimer's or other disability with a variety of issues, providing information, referral, and in some cases, preparation of documents. We assist with consumer issues, especially if you think you've been scammed with regard to some sort of contract or auto repair company. We assist with fair housing and housing discrimination. This is one area that the public really doesn't know that we get involved in. We receive funding to assist individuals under the Fair Housing Act, which protects against housing discrimination in the sale, lease, rental of housing. And so people are protected against housing discrimination in the areas of race, color, national origin, religion, sexual discrimination, familial status, and disability. We also assist in the areas of family law, guardian advocacy, guardianship, and IRS income tax issues. We have a low income taxpayer clinic that assists individuals with their IRS problems, such as denial of the earned income tax credit, fines and deficiencies that the IRS is charging due to past tax returns filed, and innocent spouse release. We have a housing unit that assists with landlord and tenant issues, and believe me, we are very busy in that area. We also assist with public benefits such as food stamps and Medicaid, and probate, and helping people get legal title to their homes, people who have inherited their homes but don't have the legal title to them unless they go to court to obtain it. One important matter that you should know is that we don't assist with the preparation of wills. We refer people seeking that help to the Hillsborough County Bar Association's Lawyer Referral Service at 813-221-7780. And if you need that number again, please let me know and we'll put it in the chat later. Next slide, please. Bay Area operates both a statewide senior legal helpline at 888-895-7873 and a statewide veterans legal helpline at 866-486-6161. Any senior can call the senior legal helpline. Any veteran can call the veterans legal helpline for legal advice on a civil legal matter, or if they just want to know what their rights are with regard to a particular problem that they're having now. These contact numbers will be provided again at the end of this presentation. The services through the Senior Legal Helpline and the Veterans Legal Helpline are free. We have offices in Clearwater, Dade City, downtown Tampa, Newport Richey, Plant City, Ruskin, St. Petersburg, and Ybor. To apply for our services, people must call our legal aid line at 800-625-2257 or 813-232-1343. Please note that Bay Area does not handle any criminal matters. And so anyone who wishes to apply for legal services must do so through those two telephone numbers that I've given to you today. Next slide, please. Today, I'll be giving you an overview of healthcare advance directives. Healthcare advance directives are documents in which you have designated who can make decisions regarding your healthcare should you become incapacitated. By pre-planning your affairs, you ensure that your directives are carried out as you want. You avoid second guessing on the part of your family members at an emotional time when they are faced with figuring out the best healthcare decisions for you. A lot of families don't discuss this, don't discuss how they want things handled should they become incapacitated. It's a subject that's very hard, for some members of the family to discuss. And so by pre-planning and putting everything in writing, you're making sure that your wishes are followed, and you're helping out your family members as well in making sure that your wishes are carried out. Next slide, please. Now, the two healthcare advance directives that I'll be speaking to you about are the designation of healthcare surrogate and the living will. If you don't have certain healthcare advance directives already in place, Florida's healthcare proxy law provides a list of persons or proxies who may make healthcare decisions on your behalf should you become unable to make those decisions on your own. The list in priority order, according to Florida Statute 765.401, starts with the court-appointed or judicially appointed guardian of the patient. If there is no court-appointed guardian, the list drops to the patient's spouse. If the patient is not married, the next person in line to serve as a healthcare proxy is the adult child of the patient. And if that patient has more than one child, then the majority of the adult children who are reasonably available for consultation can make the healthcare decisions. If the patient doesn't have any adult children, the list goes to a parent of the patient. And if there are no parents that are alive, then the list goes to the adult sibling of the patient. Or if the patient has more than one sibling, a majority of the brothers and sisters who are reasonably available for consultation can make that decision. Next slide, please. If there aren't any adult siblings, then the healthcare proxy law designates the adult relative of the patient who has exhibited special care and concern for the patient and who has maintained regular contact with the patient and is familiar with the patient's activities, health, and religious or moral beliefs. I know that I'm very close to my aunt, and yes, she has 3 children, only one of them here in Florida. And if none of the children can assist in making healthcare decisions for one thing or another, I would more than likely step up because I do have a special relationship with her. I maintain regular contact with her, and I'm familiar with her religious and moral beliefs and activities and health issues. And if there is no adult relative that can take that place, then it would be a close friend of the patient. Next slide, please. Now, the healthcare proxy law provides that if no one fits into any of the categories that I have just discussed, a licensed clinical social worker or a clinical social worker who is a graduate of a court-approved guardianship program may serve in that capacity if the provider's bioethics committee allows and approves that, and that social worker must not be employed by the provider. So the proxy has to make the healthcare decision based on the decision that the proxy believes the patient would have made under the circumstances. If the patient had not indicated what he or she would have chosen, then the proxy may consider the patient's best interests in making the healthcare decision. Next slide, please. So one may wonder, if Florida already has a healthcare proxy law, why should I be concerned about pre-planning for my own healthcare? It's already taken care of under Florida law. Well, suppose there's no court-appointed guardian or guardian advocate and you are married. Under Florida law, your spouse would be the one authorized to make healthcare decisions for you if you're not able to do so on your own. But what if you're separated from your spouse and have been for several years now? Or what if you are in an abusive relationship and you've already been hurt physically, emotionally, or both by your spouse? Would you really want your spouse making decisions about your healthcare in that type of situation? Another thing to consider is, what if you are not married? What if you have a life partner with whom you've been living for several years? Do you want that partner to be able to make healthcare decisions for you? Without a healthcare advance directive in place, Florida's healthcare proxy law will dictate who will be able to make those healthcare decisions for you. And if you have a parent, or you have adult children, or you have siblings, those are first in line before your significant other, your partner, comes into play. What if you're single or divorced and you have several adult children, one living here in Florida and the others living out of state? The law provides that the majority of the children who are reasonably available for the consultation should make the healthcare decisions. What if the one here in Florida is the one who is reasonably available for consultation, but that child, though you love him or her to pieces, is also the one with the substance abuse problem, or is the one who has stolen from you, or worse, over the years? Would you really want that child to be the one making decisions about your health care? And what if you have two children and one child opts for one type of treatment and the other disagrees? Then what's going to happen? So those are things for you to consider. Next slide, please. It's not so easy, which is why you may want to think about designating your healthcare surrogate and drawing up a living will now, while you have the ability to make those decisions. The designation of a healthcare surrogate is a witness document that allows you to authorize in advance the person you most trust to make your healthcare decisions in the event you become unable to do so yourself. Two adults, one of whom cannot be your spouse or a blood relative, must witness it. The person designated as your healthcare surrogate shall not act as a witness. Under current law, you may authorize that person to start making healthcare decisions when your doctor has determined that you are incapacitated to make medical decisions at some point in the future, or you may authorize that person, your healthcare surrogate, to begin exercising that authority immediately. The decision as far as when your healthcare surrogate has the authority to start making healthcare decisions is yours. You decide if the authority is effective immediately or if the authority is effective down the road when your doctor determines that you no longer have the capacity to make those decisions. You may also determine when you want your healthcare surrogate to have access to your medical records and medical information, including mental health records. You can decide that they're to have that information only when your doctor has determined that you're incapacitated to make medical decisions, or you may authorize your healthcare surrogate to have immediate access to your medical records and information. And again, this decision as far as when your surrogate is to have access to your medical records and information is totally up to you. You are in the driver's seat. Next slide, please. You may opt to authorize your healthcare surrogate to make decisions regarding anatomical gifts, donation of your organs, or not. We also recommend that you designate an alternate healthcare surrogate. This is your backup plan. In the event that your designated healthcare surrogate is unable or unwilling to serve in that capacity, the alternate healthcare surrogate you have chosen can step in and make healthcare decisions for you. So now that you've designated someone to serve as your healthcare surrogate and have also selected an alternate healthcare surrogate, it is really important to make sure that you discuss with them exactly what you would want done under certain circumstances. Have that conversation with them. You may want to put your wishes in writing should something happen to you and your condition is such that life-saving measures need to be taken. And that leads us to the next type of healthcare advance directive. Next slide, please. A living will is a witness document that is only used when you are incapacitated. It speaks for you at a time when you cannot speak for yourself. It must be witnessed by two adults, one of whom cannot be your spouse or a blood relative. It only applies when two doctors, your own doctor who has been treating you and knows you, and another consulting doctor both believe that you are in one of three conditions: end stage, vegetative stage, or terminal, and the two doctors believe that you have no reasonable medical hope of recovering from that condition. Each doctor must document the results of his or her examination in your medical record and sign it. Their license is on the line, and it is entered into your medical record, so it is official. Next slide, please. An end-stage condition means that it's an irreversible condition that's caused by injury, disease, or illness, which has resulted in progressively severe and permanent deterioration, and which, to a reasonable degree of medical probability, treatment of the condition would be ineffective. Examples would be end-stage liver disease, end-stage renal disease, end-stage Alzheimer's disease. A persistent vegetative state is defined under the statute as a permanent and irreversible condition of unconsciousness in which there is the absence of any kind of voluntary action or cognitive behavior. It's also an inability to communicate or interact purposely with the environment. Next slide, please. A terminal condition means a condition caused by injury, disease, or illness from which there is no reasonable medical probability of recovery and which, without treatment, can be expected to cause death. Advanced cancers, multiple organ failure, massive heart attack are all examples. Next slide, please. The two doctors who examined you and who found that you are in one of those three end-stage conditions can then look at your living will to check and see what you have indicated you want done regarding life-prolonging procedures. Life-prolonging procedures are those that would basically serve to keep your body alive longer than it would stay alive naturally. These life-prolonging procedures are things that restart, support, or take the place of spontaneous vital function. A spontaneous vital function is something that your body does all by itself to keep you alive without you even thinking about it, such as breathing, your heart beating, your body processing food and beverages. But what if your heart stops? Do you want CPR? Do you want to be resuscitated? Do you want them to use a defibrillator? If your lungs stop working on their own, do you want to be ventilated? Intubation, the use of a ventilator. If your kidneys fail, do you want dialysis provided? Okay, so all of these are hard things to think about, but in a living will, you need to indicate what you would want done under certain situations. If your living will says that artificial life support is not to be provided, next slide, please. If your living will says that artificial life support is not to be provided, it's important that you know that the law provides that you will still get pain relief and comfort care, anything to keep you as comfortable and free of pain as possible. One thing your living will won't do, it won't authorize a mercy killing. Assisted suicide is a felony in Florida, so it definitely won't provide for that. And even if you don't have anyone you trust to make everyday healthcare decisions for you, as a healthcare surrogate, you can still make a living will to make sure that doctors know what your own wishes are, whether or not life-prolonging procedures should be applied in these extreme end-of-life conditions. Now, as I stated earlier, you need two witnesses when you sign your designation of healthcare surrogate and your living will. Florida law requires that you sign in the presence of the two witnesses. Your healthcare surrogate cannot be a witness to your designation of healthcare surrogate. One of the witnesses cannot be your spouse or a blood relative, and a notary is not required. We as lawyers prefer to have a jurat or notarial certificate at the end of our legal documents, such as a living will and a designation of healthcare surrogate. It just raises the awareness that this person who is signing this legal document has presented identification to a notary, and the notary, has observed that they have signed in their presence and can attest to that. But the law does not require it. And because of COVID, about 2 years ago, we did modify our living will and our designation of healthcare surrogate forms to make it easier to send out to clients who had called and needed that. So with the proper instructions so that they could execute and sign those documents on their own in the presence of witnesses outside, because of COVID, outside where it's well ventilated, or in a room where they were socially distanced. Okay. What is important for you to know, though, is that these advanced directives give you more control over your life and what happens to your body, even if you're unconscious. What's even more important for you to know is that you may change or revoke your advanced directives at any time, so long as you are competent to do so, so long as you have the mental capacity to do so. You can change or revoke your advanced directives by 1, orally expressing your intent to revoke it, 2, by a signed and dated writing saying I revoke the advanced directives, the living will, and the designation of healthcare surrogate that I signed in 2010. You can change or revoke it by canceling or destroying the document, or 4, by signing another advanced directive that materially is different from the former one. And the revocation is effective upon informing your healthcare surrogate, your treating physician, or your healthcare facility. Basically, you should provide notice of the revocation to all the doctors and hospitals to whom you gave a copy of the directive in the first place, so that they know that is no longer in place and no longer valid. If you update your advanced directives, it is important that you inform your healthcare surrogate, your alternate surrogate, and that you provide your treating physician with the updated copy. So even though people are now beginning to go back to work in person and meeting in person, we still recommend that there be some form of social distancing when you're signing your documents. You always want to sign first with the witnesses watching you from a safe distance. You can each have your own pens just to be on the safe side. And once you have both signed or all signed, you can spray the document or just put the document away for a day or two. Next slide, please. So that's the end of my presentation with regard to the healthcare proxy law, living wills, and designation of healthcare surrogates. In closing, please remember that you may apply to Bay Area Legal Services for any kind of civil legal problem at 800-625-2257 or at 813-232-1343. All applicants will be screened for eligibility. And then in addition, always consider, if you're a senior, that the Florida Senior Legal Helpline number is handy, 888-895-7873. And if you're a veteran, keep in mind that the Florida Veterans Legal Helpline is an important resource at 866-486-6161. I hope that you found this information useful, and I thank you for joining us today. Are there any questions? I don't know if there are any questions in the chat box, Allison. Otherwise, this would conclude my Okay, thank you. This would conclude my presentation. Thank you so much for joining us today. Bye-bye.